Title 3 is all about the crimes against public order. Chapter 1, Rebellion, Coup d'etat, Sedition, and Disloyalty. Article 134, Rebellion or Insurrection. How committed? The crime of rebellion or insurrection is committed by rising publicly and taking arms against the government for the purpose of removing from the allegiance to said government or its laws the territory of the Republic of the Philippines or any part thereof, of any body of land, naval, or other armed forces, or depriving the chief executive or the legislature wholly or partially of any of their powers or prerogatives, as amended by RA number 6968, October 24, 1990. Article 134-A, Coup d'etat. How committed? The crime of coup d'etat is a swift attack accompanied by violence, intimidation, threat, strategy, or stealth, directed against duly constituted authorities of the Republic of the Philippines or any military camp or installation, communications networks, public utilities, or other facilities needed for the exercise and continued possession of power, singly or simultaneously carried out anywhere in the Philippines by any person or persons belonging to the military or police or holding any public office or employment with or without civilian support or participation for the purpose of seizing or diminishing state power, as amended by RA number 6968, October 24, 1990. Article 135, Penalty for rebellion, insurrection, or coup d'etat. Any person who promotes, maintains, or heads a rebellion or insurrection shall suffer the penalty of reclusion perpetua. Any person merely participating or executing the commands of others in a rebellion or insurrection shall suffer the penalty of reclusion temporal. Any person who leads or in any manner directs or commands others to undertake a coup d'etat shall suffer the penalty of reclusion perpetua. Any person in the government service who participates or executes directions or commands of others in undertaking a coup d'etat shall suffer the penalty of reclusion temporal in its maximum period. Any person not in the government service who participates or in any manner supports, finances, abets, or aids in undertaking a coup d'etat shall suffer the penalty of prison mayor in its maximum period. When the rebellion, insurrection, or coup d'etat shall be under the command of unknown leaders, any person who in fact directed the others, spoke for them, signed receipts and other documents issued in their name, or performed similar acts on behalf of the rebels shall be deemed a leader of such rebellion, insurrection, or coup d'etat, as amended by RA number 6968, October 24, 1990. Article 136, Conspiracy and Proposal to commit coup d'etat, rebellion, or insurrection. The conspiracy and proposal to commit coup d'etat shall be punished by prison mayor in its minimum period and a fine which shall not exceed 8,000 pesos. The conspiracy and proposal to commit rebellion or insurrection shall be punished respectively by prison correctional in its maximum period and a fine which shall not exceed 5,000 pesos, and by prison correctional in its medium period and a fine not exceeding 2,000 pesos. Article 137, Disloyalty of public officers or employees. The penalty of prison correctional in its minimum period shall be imposed upon public officers or employees who have failed to resist a rebellion by all the means in their power, or shall continue to discharge the duties of their offices under the control of the rebels, or shall accept appointment to office under them, as restored by EO number 187. Article 138, Inciting to rebellion or insurrection. The penalty of prison mayor in its minimum period shall be imposed upon any person who, without taking arms or being in open hostility against the government, shall incite others to the execution of any of the acts specified in Article 134 of this code by means of speeches, proclamations, writings, emblems, banners, or other representations tending to the same ends, as restored by EO number 187. Article 139, Sedition, how committed. The crime of sedition is committed by persons who rise publicly and tumultuously in order to attain by force, intimidation, or by other means outside of legal methods any of the following objects. Number 1, to prevent the promulgation or execution of any law or the holding of any popular election. Number 2, to prevent the national government or any provincial or municipal government or any public officer thereof from freely exercising its or his functions or prevent the execution of any administrative order. Number 3 is to inflict any act of hate or revenge upon the person or property of any public officer or employee. Number 4, to commit for any political or social end any act of hate or revenge against private persons or any social class. And number 5, to despoil for any political or social end any person, municipality or province or the national government or the government of the United States of all its property or any part thereof, as amended by Com Act number 202. Article 140, the penalty for sedition. The leader of a sedition shall suffer the penalty of prison mayor in its minimum period and a fine not exceeding 10,000 pesos. Other persons participating therein shall suffer the penalty of prison correctional in its maximum period and a fine not exceeding 5,000 pesos, restored by EO number 187. Article 141, conspiracy to commit sedition. Persons conspiring to commit the crime of sedition shall be punished by prison correctional in its medium period and a fine not exceeding 2,000 pesos, restored by EO number 187. Article 142, inciting to sedition. The penalty of prison correctional in its maximum period and a fine not exceeding 2,000 pesos shall be imposed upon any person who, without taking any direct part in the crime of sedition, should incite others to the accomplishment of any of the acts which constitute sedition by means of speeches, proclamations, writings, emblems, cartoons, banners, or other representations tending to the same end, or upon any person or persons who shall utter seditious words or speeches, write, publish, or circulate scurrilous libels against the government of the Philippines or any of the duly constituted authorities thereof, or which tend to disturb or obstruct any lawful officer in executing the functions of his office, or which tend to instigate others to cabal and meet together for unlawful purposes, or which suggest or incite rebellious conspiracies or riots, or which lead or tend to stir up the people against the lawful authorities, or to disturb the peace of the community and the safety and order of the government, who shall knowingly conceal such evil practices. Chapter 2, Crimes Against Popular Representation. Section 1, Crimes Against Legislative Bodies and Similar Bodies. Article 143, Acts tending to prevent the meeting of the Assembly and similar bodies. The penalty of prison correctional or a fine ranging from 200 to 2,000 pesos or both shall be imposed upon any person who by force or fraud prevents the meeting of the National Assembly, Congress of the Philippines, or of any of its committees or subcommittees, constitutional commissions or committees or divisions thereof, or of any provincial board or city of or municipal council or board. Article 144, disturbance of proceedings. The penalty of arresto mayor or a fine from 200 to 1,000 pesos shall be imposed upon any person who disturbs the meetings of the National Assembly or the Congress of the Philippines or of any of its committees or subcommittees, constitutional commissions or committees or divisions thereof, or of any provincial board or city or municipal council or board, or in the presence of any such bodies should behave in such manner as to interrupt its proceeding or to impair the respect due it. Section 2, Violation of Parliamentary Immunity. Article 145, Violation of Parliamentary Immunity. The penalty of prison mayor shall be imposed upon any person who shall use force, intimidation, threats, or fraud to prevent any member of the National Assembly or the Congress of the Philippines from attending the meetings of the Assembly or of any of its committees or subcommittees, constitutional commissions or committees or divisions thereof, from expressing his opinions or casting his vote, and the penalty of prison correctional shall be imposed upon any public officer or employee who shall, while the Assembly or Congress is in regular or special session, arrest or search any member thereof, except in case such member has committed a crime punishable under this code by a penalty higher than prison mayor, as amended by Com Act number 264. Chapter 3 is all about the illegal assemblies and associations. Article 146, illegal assemblies. The penalty of prison correctional in its maximum period to prison mayor in its medium period shall be imposed upon the organizers or leaders of any meeting attended by armed persons for the purposes of committing any of the crimes punishable under this code, or of any meeting in which the audience is incited to the commission of the crime of treason, rebellion or insurrection, sedition or assault upon a person in authority or his agents. Persons merely present at such meeting shall suffer the penalty of arresto mayor unless they are armed, in which case the penalty shall be prison correctional. If any person present at the meeting carries an unlicensed firearm, it shall be presumed that the purpose of said meeting, insofar as he is concerned, is to commit acts punishable under this code, and he shall be considered a leader or organizer of the meeting within the purview of the preceding paragraph. As used in this article, the word meeting shall be understood to include a gathering or group, whether in a fixed place or moving. Article 147, illegal associations. The penalty of prison correctional in its minimum and medium period and a fine not exceeding 1,000 pesos shall be imposed upon the founders, directors, and presidents of associations totally or partially organized for the purpose of committing any of the crimes punishable under this code or for some purpose contrary to public morals. Mere members of said associations shall suffer the penalty of arresto mayor as restored by EO number 187. Next, Chapter 4, Assault upon and resistance and disobedience to persons in authority and their agents. Article 148, Direct assaults. Any person or persons who without a public uprising shall employ force or intimidation for the attainment of any of the purposes enumerated in defining the crimes of rebellion and sedition, or shall attack, employ force, or seriously intimidate or resist any person in authority or of any of his agents while engaged in the performance of official duties or on occasion of such performance, shall suffer the penalty of prison correctional in its medium and maximum periods and a fine not exceeding 1,000 pesos when the assault is committed with a weapon, or when the offender is a public officer or employee, or when the offender lays hands upon a person in authority. If none of these circumstances be present, the penalty of prison correctional in its minimum period and a fine not exceeding 500 pesos shall be imposed. Article 149, Indirect assaults. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 500 pesos shall be imposed upon any person who shall make use of force or intimidation upon any person coming to the aid of the authorities or their agents on occasion of the commission of any of the crimes defined in the next preceding article. Article 150, Disobedience to summons issued by the National Assembly, its committees or subcommittees, by the Constitutional Commission, its committees, subcommittees, or divisions. The penalty of arresto mayor or a fine ranging from 200 to 1,000 pesos or both such fine and imprisonment shall be imposed upon any person who, having been duly summoned to attend as a witness before the National Assembly, its special or standing committees and as subcommittees, the constitutional commissions and its committees, subcommittees, or divisions, or before any commission or committee chairman or member authorized to summon witnesses, refuses without legal excuse to obey such summons, or being present before any such legislative or constitutional body or official, refuses to be sworn or placed under affirmation or to answer any legal inquiry or to produce any books, papers, documents, or records in his possession when required by them to do so in the exercise of their functions. The same penalty shall be imposed upon any person who shall restrain another from attending as a witness, or who shall induce disobedience to a summon or refusal to be sworn by any such body or official, as amended by Com Act number 52. Article 151, Resistance and disobedience to a person in authority or the agents of such person. The penalty of arresto mayor na fine not exceeding 500 pesos shall be imposed upon any person who, not being included in the provisions of the preceding articles, shall resist or seriously disobey any person in authority or the agents of such person while engaged in the performance of official duties. When the disobedience to an agent of a person in authority is not of a serious nature, the penalty of an arresto menor or a fine ranging from 10 to 100 pesos shall be imposed upon the offender. Article 152, Persons in authority and agents of persons in authority, who shall be deemed as such. In applying the provisions of the preceding and other articles of this code, any person directly vested with jurisdiction, whether as an individual or as a member of some court or government corporation, board, or commission, shall be deemed a person in authority. A barrio captain and a barangay chairman shall also be deemed a person in authority. A person who by direct provision of law or by election or by appointment by competent authority is charged with the maintenance of public order and the protection and security of life and property, such as a barrio captain, barrio councilman, barrio policeman, and barangay leader, and any person who comes to the aid of persons in authority shall be deemed an agent of a person in authority. In applying the provisions of Article 148 and 151 of this code, teachers, professors, and persons charged with the supervision of public or duly recognized private schools, colleges, and universities shall be deemed a persons in authority, as amended by PD number 299, September 19, 1973, and BP Bilang 873, June 12, 1985. Chapter 5 is all about public disorders. Article 153. Tumults and other disturbances of public order. Tumultuous disturbance or interruption liable to cause disturbance. The penalty of arresto mayor in its medium period to prison correctional in its minimum period and a fine not exceeding 1,000 pesos shall be imposed upon any person who shall cause any serious disturbance in a public place, office, or establishment, or shall interrupt or disturb public performances, functions, or gatherings, or peaceful meetings if the act is not included in the provisions of Article 131 and 132. The penalty next higher in degree shall be imposed upon persons causing any disturbance or interruption of a tumultuous character. The disturbance or interruption shall be deemed to be tumultuous if caused by more than 3 persons who are armed or provided with means of violence. The penalty of arresto mayor shall be imposed upon any person who in any meeting, association, or public place shall make any outcry tending to incite rebellion or sedition, or in such place shall display placards or emblems which provoke a disturbance of the public order. The penalty of arresto menor and a fine not to exceed 200 pesos shall be imposed upon those persons who, in violation of the provisions contained in the last clause of Article 85, shall bury with pomp the body of a person who has been legally executed. Article 154. Unlawful use of means of publication and unlawful utterances. The penalty of arresto mayor and a fine ranging from 200 to 1,000 pesos shall be imposed upon, number 1, any person who by means of printing, lithography, or any other means of publication shall publish or cause to be published as news any false news which may endanger the public order or cause damage to the interest or credit of the state. Number 2, any person who by the same means or by words, utterances, or speeches shall encourage disobedience to the law or to the constituted authorities, or praise, justify, or extol any act punished by law. Number 3, any person who shall maliciously publish or cause to be published any official resolution or document without proper authority or before they have been published officially, or for any person who shall print, publish, or distribute or cause to be printed, published, or distributed books, pamphlets, periodicals, or leaflets which do not bear the real printer's name or which are classified as anonymous, as amended by Com Act number 202. Article 155, Alarms and Scandals. The penalty of arresto menor or a fine not exceeding 200 pesos shall be imposed upon, number 1, any person who within any town or public place shall discharge any firearm, rocket, firecracker, or other explosive calculated to cause alarm or danger. Number 2, any person who shall instigate or take an active part in any charivari or other disorderly meeting offensive to another or prejudicial to public tranquility. Number 3, any person who, while wandering about at night or while engaged in any other nocturnal amusements, shall disturb the public peace. Or number 4, any person who while intoxicated or otherwise shall cause any disturbance or scandal in public places, provided that the circumstances of the case shall not make the provisions of Article 153 applicable. Article 156, delivering prisoners from jail. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period shall be imposed upon any person who shall remove from any jail or penal establishment any person confined therein, or shall help the escape of such person by means of violence, intimidation, or bribery. If other means are used, the penalty of arresto mayor shall be imposed. If the escape of the prisoner shall take place outside of said establishments by taking the guards by surprise, the same penalties shall be imposed in their minimum period. Chapter 6, Evasion or Service of Sentence. Article 157, Evasion of Service of Sentence. The penalty of prison correction in its medium and maximum periods shall be imposed upon any convict who shall evade service of his sentence by escaping during the term of his imprisonment by reason of final judgment. However, if such evasion or escape shall have taken place by means of unlawful entry, by breaking doors, windows, gates, walls, roofs, or floors, or by using picklocks, false keys, disguise, deceit, violence, or intimidation, or through connivance with other convicts or employees of the penal institution, the penalty shall be prison correctional in its maximum period. Article 158, Evasion of Service of Sentence on the occasion of disorders, conflagrations, earthquakes, or other calamities. A convict who shall evade the service of his sentence by leaving the penal institution where he shall have been confined on the occasion of disorder resulting from a conflagration, earthquake, explosion, or similar catastrophe, or during a mutiny in which he has not participated, shall suffer an increase of 1/5 of the time still remaining to be served under the original sentence, which in no case shall exceed 6 months if he shall fail to give himself up to the authorities within 48 hours following the issuance of a proclamation by the chief executive announcing the passing away of such calamity. Convicts who under the circumstances mentioned in the preceding paragraph shall give themselves up to the authorities within the above-mentioned period of 48 hours shall be entitled to the deduction provided in Article 98. Article 159. Other cases of evasion of service of sentence. The penalty of prison correctional in its minimum period shall be imposed upon the convict who, having been granted conditional pardon by the chief executive, shall violate any of the conditions of such pardon. However, if the penalty remitted by the granting of such pardon be higher than 6 years, the convict shall then suffer the unexpired portion of his original sentence. Chapter 7 is all about the commission of another crime during service of penalty imposed for another previous offense. Article 160. Commission of another crime during service of penalty imposed for another previous offense. Penalty. Besides the provisions of Rule 5 of Article 62, any person who shall commit a felony after having been convicted by final judgment before beginning to serve such sentence or while serving the same shall be punished by the maximum period of the penalty prescribed by law for the new felony. Any convict of the class referred to in this article who is not a habitual criminal shall be pardoned at the age of 70 years if he shall have already served out his original sentence, or when he shall complete it after reaching said age, unless by reason of his conduct or other circumstances he shall not be worthy of such clemency.